And we've got Mr. Randazza for defendant. And then Mr. Kazaya, are you the pro hac vice? I don't hear you.
By the court's pardon, I am the sponsoring attorney, Your Honor.
Yes, okay, thank you. All right, Mr. Randazza, your motion.
Thank you very much, Your Honor. Your Honor, as you've probably noticed looking at the file, there are hundreds of pages of exhibits here. Really, to boil it down and to boil down what this motion's about, I think we first have to have perhaps an opening scene where we introduce the characters. Mr. Rekieta is, I suppose if you were to sum him up, a legal comedian. He spends his Saturday nights on camera discussing legal issues, always in a humorous tone, often in a tone that personally is not my cup of tea, including at least one time directly insulted my law partner. In fact, that's how I came to know him. However, this is just par for the course. It's as if he's the triumph, the insult comic dog of the legal profession. Now, on the other side, we have Mr. Quest, and I say that with quotes. I am not stipulating that that's actually his name. He has had at least claimed name changes, but let's refer to the plaintiff as Mr. Quest. Mr. Quest has sought and frankly achieved fame since at least, I would say, the early 2000s. I sincerely hope the court is not familiar with the original video, Two Girls, One Cup. I would like to summarize it by saying, despite a career where I have had to watch pornographic movies as part of my First Amendment practice, it shocks me. I've never made it past the first 7 seconds of it without having an adverse reaction in my stomach, and I'm not being hyperbolic. However, Mr. Quest stormed onto the scene then. When that video came out and produced his own version of it, one in which he showed himself and a child's doll consuming what was supposed to be feces and then engaging in, I would say, sexually charged acts. That certainly got him a great degree of notoriety. Over the years, he enjoyed that notoriety and built upon it. He claims to have been the originator of the theory, and I use that term loosely, that no one actually died at Sandy Hook. In fact, he's expressed some umbrage that such theories have been credited to other people. He's got at least 71,000 YouTube followers as of today. He has used that fame and used that platform in ways that, frankly, I find disturbing, threatening Dr. Fauci, for example, whether you agree or disagree with Dr. Fauci's positions or how he executed his duties, actually threatening him, I think, is beyond the pale. And he has also used that platform in order to attack people who he thinks are his perceived enemies, including Mr. Rekieta. I think since at least 2019, these two gentlemen have been in conflict. And since then, he has attacked Rekieta, I'd say calling him, I think just some of the examples I have here on my outline, but a non-exhaustive list, referring to Mr. Rekieta frequently as a quote-unquote retard, con man, fraud. And the two of them have certainly gotten into it, so to speak. But there is no doubt here through all of these pages of exhibits that we show going back decades that Mr. Quest is indeed a public figure. Now, my friend, Mr. Schneider, has objected to many of these exhibits as improper, but we are not submitting these for the truth of the matters asserted. Simply that this public controversy has gone on and on and on for more than a decade. One of the other hallmarks of Mr. Quest's online presence is a strange claim that he is a member of the intelligence community, meaning CIA, FBI, and that he will dox, meaning reveal personal information about anybody who he perceives to be one of his online enemies. So having shown that he is a public figure and he has willfully courted that public figure status, we then have to set up two rules of law that we should examine. One being just whether he can seek liability, he can seek, let me restart there. What standard by which he must prove a defamation claim? Since he's a public figure, he's going to have to show by clear and convincing evidence that indeed Mr. Rekieta stated these things about him, knowing that they were false or with a reckless disregard for the truth. Now, something is not false if it is an opinion, or frankly, if it is a joke, especially if it is labeled as such. Now, I can forgive, again, my friend Mr. Schneider for perhaps not watching the entire video of Mr. Rekieta insulting his client. Like I said, perhaps it is tedious to do so, but we do show in our papers that almost every statement that he said, he is qualified as, I'm joking here, except for one, and begging the court's pardon, but there's going to be some risque content in here, where he claims that Mr. Quest, quote unquote, fucked a watermelon, end quote. I have reviewed the video in question, and I have reviewed dialogue by Mr. Quest talking about it, and I can absolutely say with authority, there is a false statement of fact in that. The melon was not a watermelon, but it appears to be a honeydew. I mean, this is the kind of thing that Mr. Quest is suing for defamation over. If we look at each and every statement, to the extent that we can divine them from the amended complaint, we can find that they are either statements of hyperbole, statements of opinion, or they are backed up by evidence that is in the record that shows them to be true. Which brings us to the next point, and frankly, I think an important one, and that is choice of law. As Your Honor noted, we have invoked Colorado's anti-SLAPP law because that is the state of residence of the plaintiff. Now, the plaintiff alleged this in his complaint, and prior to ever filing an anti-SLAPP motion, I always ask the plaintiff if they'd like to amend their complaint, because I do not wish for perhaps somebody to have written something hastily, trying to get in under a statute of limitations, not having had time to think about it, to be stuck with the complaint that they start with. At no point did I ever suspect that one of the things he had to clean up was state of residence. But in the amended complaint, yet again, Mr. Quest claims to be a resident of Colorado. As such, we invoked the Colorado anti-SLAPP law because the most significant relationship to a defamation plaintiff's claim is where is his reputation centered, which is almost always where he lives. This is a rule of law that is not just some obscure thing. This goes right back to the jurisdictional case of Calder versus Jones before the Supreme Court, where the Supreme Court saw that since the plaintiff's residence and reputation were centered in California, that California was both the proper jurisdiction and the proper place for the law to be imported from. Same here. Now, Mr. Quest does claim that he is on some kind of sabbatical in Illinois, claiming only after he realized that Colorado had an anti-SLAPP law that did apply, inconsistently with both of his versions of his complaint, that that's where he really is. However, he has shown in his sworn affidavit, he hasn't changed his voter registration, hasn't changed his vehicle registration, and can still be served with process there. And in fact, my friend Mr. Schneider himself averred that he wasn't even aware that Mr. Quest was allegedly in hiding in Illinois. Accordingly, I cannot see how Illinois law would apply, but this court should apply Colorado law. Applying Colorado law, only creates one great distinction between Minnesota law and Colorado law. There is only one great distinction that you need to be concerned with, Judge, and that is the fact that Colorado's anti-SLAPP law does apply. Now, there is some question here, and I think a very interesting legal question that Mr. Schneider raised, and that is whether or not the Minnesota Constitution would tolerate the application of the Colorado anti-SLAPP law. And I think it would. The Minnesota Supreme Court did invalidate your anti-SLAPP law to the extent that it was a version of the law similar to the one that Washington State had that supplanted the role of the jury in weighing evidence. It required clear and convincing evidence in order to move past the motion. And that has been held both by Minnesota and Washington to be a violation of a Seventh Amendment right to a jury. Nevada's also had this defect, which we cured in 2015. So here you do not have that issue. What you really need to show here is that there is enough to get over a directed verdict. You don't need to weigh the evidence. There's no competing evidence here. The only competing evidence we have is, well, perhaps the complaint and Mr. Quest's affidavit, which claims that he doesn't live there, but that he does live there. This is not the kind of thing that gets you past an anti-SLAPP motion. Now, the one final thing that I think Mr. Schneider has raised that we should address is that we can't possibly grant this without discovery. However, that's not how anti-SLAPP works. And frankly, it's not even how summary judgment works. There is a procedure in Minnesota, which is familiar to me, even as a non-Minnesota attorney, because it's identical to Rule 56D of the Rules of Federal Civil Procedure, 56.04. And what that requires is if you file a SLAPP suit, or frankly, you file any kind of a suit, you face summary judgment, and you wish to avoid summary judgment, you cannot simply recite the words, "I wish to take discovery." You must provide an affidavit laying out exactly what it is you don't have and what it is that you need in order to prove that. Now, there is only one thing in the opposition that they raise, and that is Mr. Quest's medical records, which I don't see how taking my client's deposition, or frankly any discovery from my client, would achieve that goal when that should be in the hands of the plaintiff. So, Your Honor, in short, if prior to any questions you may have for me or prior to my friend's presentation, I don't mean to say this irreverently, but this case is a joke. And what I mean is it's two guys who talk smack on the internet, and one of them has decided to create a lawsuit, as he has in the past, which we show in the exhibits, because I feel like he may feel like Mr. Rekieta has something to gain from Mr. Rekieta, or he simply feels like Mr. Rekieta may have got the best of him. But I think if you look at somebody who has stepped into the ring here, he stepped into the ring voluntarily, stepped into the ring of fame, stepped into the ring of verbal combat with Mr. Rekieta. And, I'm very sorry if he doesn't like how he's been characterized, but he has not been characterized in any way that's tortious. And just as a final housekeeping matter, I would like to proffer all of the exhibits that we have attached for the court's consideration, submitted through Mindy's. Thank you very much, Your Honor, and I'd like to either be ready for questions from you or pass the talking stick to my friend, Mr. Schneider.
Mr. Schneider.
Thank you, Your Honor. May it please the court. I noted in the 53 pages of prose between defendants' memorandum in support of their motion to dismiss summary judgment and to apply Colorado law, and in reply to my memorandum opposing their motions, they only make two references to Leyendecker versus Asian Women United of Minnesota, 895 Northwest 2nd, 623, Minnesota Supreme Court, May 24th, 2017. That case is a seminal case. Mr. Randazza states on page 7 of his reply memorandum that I essentially misrepresent my cases. I feel compelled to read from Leyendecker based upon that. Starting with the syllabus, Your Honor, Our Minnesota Supreme Court said Misc. 55402 as applied to torts cases violates a party's right to a jury trial under Article 1, Section 4 of the Minnesota Constitution. They go into great length on Minnesota law on this subject and conclude on page 636, stating, thus, a district court's ruling on anti-SLAPP immunity necessarily decides the merit of the tort case itself. This result unconstitutionally abridges Article 1, Section 4. Again, Leyendecker at page 636. If we go on to page 637, the Leyendecker court further holds, the legislature can immunize a category of people from lawsuits, but it cannot interpose the district court as the fact finder in actions at law. Defendant seeks to be the apologist for Colorado's anti-SLAPP law. And judge, from my review of the law, its burden is lower than the Minnesota version that was indeed found unconstitutional. But even though it may be a lower burden, it still flies in the face of the holding from Leyendecker. Leyendecker is not an outlier. Indeed, if you've read the cases, I believe there are a total of 7 Leyendecker cases. In this last one, I've perhaps inartfully called Leyendecker 2017. Our appellate courts call it Leyendecker 2. Following that case was an unpublished Minnesota Court of Appeals decision called Diagnostic Imaging versus Hooten, case number A16-0241, where the Leyendecker court, the Supreme Court, directed the Court of Appeals to determine if the same logic they applied in the Leyendecker decision should apply to contract cases. And indeed, our Minnesota Court of Appeals agreed. It's not just tort cases, but also contract cases. Leyendecker is the law of the land in the state of Minnesota. Minnesota is indeed a case that follows the most significant relationship test when we have, I don't want to call it a conflict of law, but a choice of law. And I briefed State versus Castillo versus Alvarez, a Minnesota Supreme Court decision from 2013. And one can see in certain instances how Minnesota's law would take precedence over another state. But the Castillo-Alvarez court made it very clear that test, the most significant relationship test, is not appropriate when it is contrary to a strong public policy in Minnesota. I cannot think of a stronger public policy than the right to a jury trial, and any infringement, any impediment, however weak Colorado's so-called anti-SLAPP law may be in comparison to Minnesota's, Washington's, and Nevada's more robust law, it is still an impediment. And thus, imposition or use of any impediment to getting to a jury trial on these facts would be unconstitutional. Now, as to the matter itself, Mr. Randazza essentially calls these, well, I don't know what he calls them. My client is upset. I have submitted videos. Mr. Shepard, one of the lawyers working for Mr. Randazza, kindly transcribed them. They are clear. Mr. Quest was called a pedophile. He is not charged with pedophilia. He was not convicted of pedophilia. A false accusation of a crime is defamatory per se. That's Longbean, Longbehan versus Shanerock, Schoenrock, Minnesota Court of Appeals decision from 2007. He also, Your Honor, received a video by disc, and for whatever reason, MD's wasn't working this morning. In my memorandum to you, Your Honor, I wrote that after we finished briefing this matter, Mr. Rekieta would continue posting videos. He did so on April 1st, 2023. It's quite long. At least 30,000 people have viewed it. But in addition to what you've seen, Your Honor, and what you've read, what Mr. Shepard transcribed for us, Mr. Rekieta now threatens to rape Mr. Quest. He also threatens to rape me. Perhaps Mr. Rekieta is following a script written by Alex Jones, because then Mr. Rekieta begins screaming at me, calling me an idiot, among other epithets. Your Honor, Exhibit 25, the Minnesota Lawyer article written by Kevin Featherly is accurate. Mr. Rekieta has created an online hate factory. Now, who is a public figure, a limited purpose public figure, has been briefed extensively. Both sides rely on the Gertz versus Robert Welch decision as a basis. That's a U.S. Supreme Court case from 1974. Minnesota has adopted it in Shafulias versus Peterson. That's a Minnesota 2003 case. But the number one requirement in order to be determined to be a limited purpose public figure is whether a public controversy ever existed. But for this lawsuit, Your Honor, I would never have heard the name Steve Quest before, and I would not consider anything Mr. Rekieta does, at least in Wilmer, Minnesota, capable of rising to become a public controversy. A public controversy might be funding for building a border wall, or defending lawsuits brought by people who were heard on January 6th, or you can imagine a number of other such instances. But people on the internet, these two people, specifically my client, cannot stand to be a public, there is whatever controversy there is a public controversy. I cited in brief the McGuire versus Bolin decision, Your Honor. A high school basketball coach from a large suburb of Minneapolis, Woodbury. Following high school basketball, I can't imagine that a basketball coach is not a limited purpose public figure. The district court would have agreed with me. The Court of Appeals agreed with me. The Supreme Court disagreed and said, no, there is no public controversy given those facts when you're just simply talking about someone like a basketball player. So I don't see Mr. Quest as being a public figure. With regard to the negligent infliction of emotional distress and intentional infliction of emotional distress, part of what the plaintiff must do in such instances is produce evidence of harm, serious harm. For instance, medical records. In fact, one case, Bowden versus All2 Manufacturing, that's a Minnesota Court of Appeals decision from 1987, requires that there be severe emotional distress with attendant physical manifestations. Your Honor, some of these things that Mr. Rekieta has said about Mr. Quest just happened, are just happening. The records are being generated as we speak. It's impossible to disclose something that hasn't been generated yet. And I am grateful to counsel for citing the Ringsred versus City of Duluth decision. If you look at Mr. Randaz's reply brief on page 7, he cites Ringsred. And Ringsred is an interesting case because it's a defamation case that was dismissed at the district court level, but then largely reinstated at the appellate level with one exception. And that one exception was Ringsred did not offer any evidence as to actual malice by the people who defamed him. Well, if you read Ringsred, the exact language goes like this. So last page of Ringsred, that's September 19, 2022. Again, it's an unpublished decision. It's noted as A as in Adam 22-0374. Reading Ringsred, the court writes, but Ringsred conducted no discovery and placed no facts on record. Only a district court decision from one of his lawsuits against the city. Because Ringsred failed to demonstrate a genuine issue of material fact as to actual malice, municipal respondents are entitled to summary judgment. I think discovery is really important, Judge, if the evidence is being developed as we speak and will be developed over time. And unlike the Ringsred decision, I fully intend to conduct discovery. So I don't think Ringsred stands for the proposition proffered by Mr. Randazza. A case like this and the choice to declare documents as evidence at any level, I use in my practice on cases where we are well into discovery. especially on matters where there will be no dispute as to how the person collecting the evidence is collecting it. It's never a matter of controversy. In this case, Your Honor, you're going to see videos that are attributed to one individual that through the development of facts through discovery will find really wasn't created by that individual. You're going to hear and see comments that say one thing on its face, and then upon viewing it, something quite different is said. Right now, I think the only record we have is what I've submitted because I use affidavits. And for that reason, and that reason alone, I believe the court would be correct in simply denying summary judgment on all counts and the request for dismissal and to impose Colorado law, and then order us through discovery. There's no harm in discovery. In fact, the defendants may frankly find other reasons to move for summary judgment or may not find reasons to move for summary judgment. But through discovery, at least the court will have a record upon which to rule. That's all I have, Your Honor. Thank you.
All right, I will take the motion under advisement.
Thank you, Your Honor.
Your Honor,
Yes.
would it be improper for the defendant to have a rebuttal?
Not improper, but I'm not granting that today.
Well, thank you anyway, Your Honor. Have a wonderful
Thank
day.
you, Your Honor.
Thank you.